Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Here's your host, attorney Anthony Reeves.
For those of you who are applying for workers' compensation, I typically get questions asking me, will workers' comp hurt my case? And the tough thing about workers' compensation is that invariably there's a chance that it might. And you're saying, well, what do you mean by invariably? Let's look at it from a couple of ways. One of the things that you routinely have, and first of all, let me make sure I throw this caveat here. I'm talking about workers' comp in an umbrella sense, and like I did with the video I did a couple days ago. But remember, workers' comp is state specific, so just keep that in the back of your mind. The problem that you run across is that one of the things, there's two problems that pops into my mind. One of the things is what we call maximum medical improvement. Under workers' comp, maximum medical improvement basically means the most improvement that you sustained as a result of the treatment that you've undergone and that you're not going to improve any better. Basically, you've hit that plateau where they've done all they can, you're not going to get any better than that. You're like, okay, that might be great. Well, here's where it gets tricky. Depending on what your limitations are, those limitations may be something that may prevent you from doing your work that you were doing when you got the workers' comp injury, but it may not keep you from, it may not necessarily mean that you can't do anything else. Remember, this is where people get a little lost in translation. Social Security is really kind of an all or nothing type of beast, meaning they want to know not only can you no longer do the work you used to do, but they also want to know, can you do anything else? So let's give you a good example. Let's say you're in your 30s. You had slip and fall at the workplace. You had a job that caused you to do heavy, medium to heavy, like heavy to very heavy work. So basically, after all the treatment you've gone through, they determine that you have the residual ability, even with all of your conditions, to do light work. So you're thinking, party people, come on, get funky. Yeah, you're thinking, great, I can't do my past work doing medium to very heavy work. But you're young and you can do light work. Guess what? There's all kind of work Social Security can find for you to do. So unless you can demonstrate that the limitations set forth by the workers' comp doc and it is less than that, and it might be, and it can be. Now, here's where you need to understand. This is where Social Security's regs with regards to saying that they consider all of your severe impairments are important. Let's say you have depression really bad and you have your back is bad. Well, under workers' comp, they're not looking at your depression, they're only focusing on your back. Well, they may say you can only do light work, but then your depression might be at such a level that it just prevents you from being able to do light or sedentary work. So they look at everything, okay? But what we're here today is to talk about how workers' comp could possibly hurt your case. So let's say that the example I provided, you are only alleging that you can't work because of your back, and you're in your 30s, and you graduated from high school, and your work you've been doing is construction work, which is basically heavy to very heavy work. Guess what? If the workers' comp has made a determination that you can only do light work, you're kind of in a tough spot. Why? Because in this instance, you've got all these longitudinal care and that's accumulated to this one particular point where they've determined you can do light work. There's going to be work they're going to find you can do. That's the first issue. Second issue is that once workers' comp case is settled, typically in some areas, you're not getting any more medical treatment. So think about it like this. You apply for, let's say you got hurt in 2013. You apply for workers' comp and you apply for Social Security around the same time. They settled your case in, let's say you got hurt in October 2013. They settled your case in June of 2014. Guess what? All that treatment that you were receiving, done. Done. So now by the time you have your hearing in May or June of 2015, you haven't been to any specialist because why? All of your specialists was through workers' comp. So you have nobody who's following up with you who can give an opinion about your ability to do any work beyond that date. See what I mean? So unless you know, and I can't tell you the number of times I've had people come to me and say, I can't afford to go to the doctors that they had me going to, but I need to go to those kind of doctors, but I can't because I no longer will workers' comp. Therein lies your issue. Now, this is one of those times where I tell people, you don't have to do it. You're a grown person. You can do whatever the hell you want to, but you probably really need to sit down and talk to a representative, because you need someone who can sit down and tell you what type of impact, whether good or bad, your workers' comp evidence is going to have on your case. Because every case is a little different, every judge is a little different, and every circumstance is different. There's a possibility that information could hurt your case.